Thank you, Kyle, and thank you everyone for joining today. I'm Bruce Bagelman, Chair this year of the Civil Litigation Section. I'm pleased to welcome Paula Sweeney, who's going to be giving a presentation on cross-examination today. Paula is a partner in the Dallas office of Slack Davis Sanger, who practices in the area of healthcare liability, but also works on other complex medical products and traumatic injury cases from the plaintiff side. She's a fellow of the American College of Trial Lawyers, that has been a fellow of the International Society of Barristers and the International Academy of Trial Lawyers. She's a past president of the Texas Trial Lawyers Association, the Dallas Trial Lawyers Association, and the Dallas chapter of ABOTA, and previously served as a governor of the Association of Trial Lawyers of America and on the board of directors of the State Bar of Texas. Paula served 15 years on the Texas Supreme Court Rules Advisory Committee and also served on the Supreme Court Task Force on Medical Malpractice Discovery, the Supreme Court Task Force on the Jury Charge, and chaired the Chief Justice's Task Force on Judicial Selection Reform. Among many honors, some include the Champion of Justice Award from Texas Watch in 2022, the Don Bowen Distinguished Lifetime Lawyer of the Year, being named a Legend of Trial Law by the Dallas Bar Association, recipient of the Legal Education, Continuing Legal Education Award in Texas, Texas Nurses Association Healthcare Professional of the Year Award. She's been a D Magazine Best Lawyers in Dallas every year since 2001, Texas Monthly Super Lawyer every year since 2003, and Texas Lawyers Extraordinary Women in Texas Law and Top 50 Women Lawyers in Texas and Best Lawyers in America since 1995, and the recipient of the Dallas Bar Association Trial Lawyer of the Year in 2013. For fun, Paula loves to gallop large horses at immovable objects and jump over them, enjoys 20-mile hikes in Glacier National Park, runs half marathons, and in general lives by her lodestar, quote, bitching, not just a right, a responsibility.
I didn't know
Although
that.
not listed as an honor, I would be remiss in not mentioning that I'm married to Paula's sister, so she is my sister-in-law, and without further ado, present to you Paula Sweeney.
Thank you, Bruce. I appreciate that. I did not realize that little line was on the bottom of the bio. Yes, I do like riding horses, but don't usually bring it up at CLEs. Anyway, everybody, hello. It's a pleasure to be with you today. I am looking forward to talking about my favorite thing to do, which is cross-examination. I've been trying cases now for 40 years. I do all medical malpractice. So to me, they're fascinating cases and the medicine is fascinating. Every case presents a new set of facts and a new set of issues to learn. And I find that in the cross-examination process, that's where we really get to dig into the meat of what the case is about and what we're trying to prove. As a plaintiff's lawyer, I always have the burden of proof. I, however, think that cross-exam, if we're doing it right, we are proving something. And so in that sense, whenever you're cross-examining somebody, you have a burden to prove or disprove something. I think it's the most fun that you can have in a lawsuit. I also really love that moment when the judge says, plaintiff, are you ready? And I really, really love that moment at the end of the trial after the other side has given his closing argument when he says, now in another minute, she's going to get back up here. And I know I have those last few precious minutes to just go whole hog on the rebuttal closing. But cross-exam is about as much fun as you can have during the trial. So let's dig in. Where are we going with cross-exam? If I can get my PowerPoint to move. All right, for some reason it isn't moving. It was, we practiced. There we go. So obviously we've got cross-exam that is different in deposition and in trial. And I want to talk about both of them and about the differences. I'll all the way from technique to order to speed to a number of the differences. One size does not fit everybody, and that includes the witnesses and it includes the lawyer. I can't cross-examine the same way a large man can. A large man cannot cross-examine the same way I can. I can get up closer to a witness and be much more direct and aggressive, whereas other folks have to take in their own physical age, status in making their decisions about cross. So we'll talk about that. And then I really, really want to talk about this last point. Why am I doing this cross-examination? You know, just because the other side lists someone as a witness, why, especially with depositions, why are we deposing them? Do we need this? If you've got a report, if the court has ordered a report under a scheduling order or under the applicable rules, if it's an expert and you've got a report, or you've got some other kind of sworn statement, or you know what you're going to prove, why take a deposition? Sometimes we get, especially I know in complex cases, we get caught up in this sense that every important witness has got to be deposed. I question that, and I want to talk about that as we move along with the different kinds of questions. So let's start with depositions, because realistically, and I know some of you folks are criminal law practitioners and won't be doing as many discovery depositions as we do on the civil side, but there are still enough that that it makes it important to talk about it. So rules for depositions, scripts. Okay, you know, I tell my plaintiffs, all right, he's a 5-year lawyer and he's got a yellow pad and it's 10 pages long, and he's going to start out with, please tell me every place you've ever lived. Please tell me every name you've ever used. Let's start with your educational background. Where did you go to high school? And I tell him, you know, by the time you're 10 minutes into this, you're not going to be nervous anymore, because you're going to be bored and you're going to be comfortable and relaxed. And so question, why do we start that way? Why do we start out with this predictable script that immediately makes the other witness comfortable? They know where you're going. They know what you're going to do next. Why relax them? Why soothe them? Why calm them? Why make it this is cross. This is not putting your own person on the stand trying to get them comfortable. Why are we trying to make them comfortable? So an example from a deposition, this is a defendant, a doctor. And we started the deposition. The issue in the case, the defense in the case is that our lady didn't suffer from what we say she suffered from, but she had a pulmonary embolism. So state your name, Dr. Gray. Isn't it true? It would be speculation to say that Ms. Wright had a pulmonary embolism. Boom, kabam. He's not comfortable yet. Yes, sir. This my partner asked this question. Yes, it would be speculation. That's it. We're done. We're done. Now, we went on and did some other stuff in the deposition. Let's get your background. Where'd you go to medical school, etc. But right there out of the box, first question, the heart of the case, he's not comfortable. He's not ready. He doesn't have his arms folded arguing with us yet. And there it went. So that case got resolved. So that's one approach that, you know, we don't do that very often. And it tends to bear a lot of fruit. This is an example of the opposite, which is to make the witness uncomfortable. This is the 12th line of, I think, about the 3rd page of this defendant doctor's deposition. And I'm asking about her background and where did you go? And she applied to 7 medical schools. She was only admitted to 2. And I already know she's a DO. And if you've got DOs in your family, don't send me a mean email. The point of this is not to discredit DOs as opposed to MDs. It's to make this witness uncomfortable. Well, the only 2 schools she was admitted to were West Virginia Osteopathic and Western University. Did you apply to any allopathic schools? And of course, we'll explain that to the jury when we get there. Allopathic is MD, osteopathic is DO. Were you accepted by any allopathic med schools? No. All right. Already now she's mad, she's irritated, she's uncomfortable, and she feels like she's been dissed. And she has been dissed, and it's, you know, we're page 3 or 4 of the deposition. It was intentional. I wanted her dissed, But consider that if you know you're going to get some traction along a line like that, put it right out there at the beginning and get them uncomfortable. Rule number 2, and this is my favorite part of deposing, is keep moving. The rule is never go back once you get a cookie. Do you know what I mean by a cookie? All right, I'll admit I'm a nerd, Lord of the Rings nerd. You know, at the very end of Lord of the Rings, when Gollum finally gets the ring and he's dancing around with it and he's cheering and he's on the edge of the pit of fire, and what happens? He's got his cookie, he falls into the pit of fire because he spent so much time celebrating and playing with the cookie that something bad happened to him. It's the same in a deposition. You get a key answer from a witness. Don't keep playing with it. Sometimes save it for later. Sometimes save it for trial. Sometimes circle around it. And I'll explain what I mean by all of those things. But you get a key admission from the witness. If you keep playing with it and dancing on the edge of the pit of fire and keep asking him and drilling on it, they are going to figure out, I didn't mean, well, no, ma'am, no. You know, what I really meant was, and boom, there goes your cookie. So keep moving once you get that cookie, get the answer. The court reporter wrote it down. You don't have to keep going back over it. It's there. And so what I mean by save it, here's an example. This is a doctor. The issue in the case is he had over-medicated our lady, and he walked into the deposition and announced that no, she didn't die because she was over-medicated by a combination of these bad drugs, that instead she had sepsis. Well, okay, I've done med mal for 40 years. I know about sepsis. One of the things that happens in sepsis is you can get a thing called osmotic diuresis, which is where the fluids in your tissues basically leach out into the rest of your body instead of staying where they're supposed to stay, in a very shorthand way to put it. But osmotic diuresis is a thing in sepsis. So okay, smart guy, and he had a little cheat sheet he had written down after he decided the day before while he's talking with his lawyer that it was sepsis and not drug overdose. So when I'm asking him about sepsis, he says, and I don't know if this is cut off on y'all's screen or not, but I don't think I can fix that. But she said she was having diarrhea. What that makes the diuresis and diarrhea are not the same thing. Jury's going to know that pretty quick. So I say I was talking about osmotic diuresis. All right, he's done. He's toast. I am not going to stay here and keep talking about this while he racks his brain and figures out, what did I learn in medical school about sepsis and the difference between diarrhea and diuresis? I've got him here. He does not know what he's talking about. We're done. We didn't talk about this again for the whole deposition because he's clueless. So there's a cookie. Sorry to mix the concepts of diarrhea and cookies on the same screen, but while you guys are eating lunch, apologize for that. But in any event, the concept is don't keep flailing away at it. This other approach, circle around it, is something that also is very helpful. This is a nurse. There's a drug called lidocaine. You guys know about it. In part, it's a cardiac drug. It comes 2 ways. It comes in a long, skinny, small needle that gives you a 100 milligram dose. It's meant to be given all at once. You inject it into the little IV port. It also comes in a great big syringe with a tube around it that has 2,000 milligrams that's meant to go into the IV bag and be deleted and drip in over a process of hours. Our hero, this lady, wrote in the notes after our guy died because he got 2,000 milligrams all at once because she picked up the wrong syringe instead of 100 milligrams. She wrote it in the medical record. So I walk into the deposition kind of fat, dumb, and happy because she's already acknowledged that she injected with the wrong syringe, and brilliantly asked, you acknowledge you used the wrong syringe, right? I changed my mind. It took me a second to react. I changed my mind. And then she said, I say, did someone suggest you should change your mind? Objection, privilege. Okay, someday we'll do a talk about objections. Suborning perjury is really not privileged, but Be that as it may, all right, we're trial lawyers, right? We're combatants. Somebody does something like this objection. What do we want to do? The first thing you want to do is, this is privilege. You can't tell witnesses to lie. All right, we want to join issue right then and there. But there's a better way, because the purpose of the deposition, why am I doing this, is, among other things, to prove this lady picked up the wrong needle and used it, right? So instead of engaging in a big fight about privilege, you go around it. When did you change your mind? Yesterday. Where were you when you changed your mind? In my lawyer's office. All right. So who, what, when, how, why, where, those are not privileged things. And now we have danced around instead of having a direct fight with the lawyer or the witness about changing your mind. I don't care about anything else. We've now established she changed her mind in her lawyer's office the day before the deposition about something that she had admitted in the medical record. So it's pinned down. We're done. I've got my cookie. I'm out of there. All right. This is a thing I learned from a very smart old lawyer when I was a not very bright young lawyer, and it's the use of inflection. And this was a gentleman who was had been doing it a long time, and he would slide his glasses down his nose and he would say, "I see." But what he did, I had my expert up, and my expert had testified at great length about how this was a deviation from the standard of care, and that the defendant had messed up and it had caused our injury. This wily old lawyer went at great length through the opinions and confirmed. So you're saying, the question before this, you're saying he violated the standard of care. Yes, I am. Yes, I am. But you're not saying he was negligent, are you? He made negligent sound like something that you picked up on the bottom of your shoe walking across the park. All right. He made it sound somewhere next to child molesting with the inflection that he used. And I had not prepared my expert properly. And he said, "Oh, no, gosh, no, not negligent. No, just below the standard of care." Well, great. So we go out in the hall. I talk to him a little bit. He comes back in and goes, "Yes, I meant negligence," but by then the damage was done. So the inflection is what yielded that. It's not an argumentative question per se when you just read it on the screen, but the way he said it, my expert felt like, "Oh God, I guess I must not be saying that." So that's one use of inflection. The other is to use an argumentative term like horrifying, but use it and this is something as a woman I find very effective when I want to prove my damages and I want the other side to agree that what's happened to my client is pretty horrifying. If I go, "Oh my God, how horrifying. Oh, what a tragedy." Well, the other witness who does not want it to be that way is going to push back and say, "Oh, people survive it all the time, lady. It's not that bad." But if you slide it in there, well, that can be pretty horrifying, can it? You're going to get a yes a big percentage of the time, where if you're waving your arms being argumentative, you won't. So consider slowing down enough to use inflection in a way to get the agreement that you want when you would not if you inflected it the other way. All right, this is a real important technique, and I emphasize this to the young lawyers in our office. You guys remember My Cousin Vinny, one of my favorite movies, right? And my cousin Vinny demonstrated something, and I didn't put the clip in because it's too hard to transmit. But the point of MEC questions is to take very small steps. And this is what Vinny does. A bad example would be, "So isn't it true you couldn't really see the old Sacco Suds, remember, across the street there?" And of course, the witness is going to say, "No, I could see real good. It's right across the street." But if you do it the way Vinny did, all right, remember, he's got the pictures out. Now, what are these pictures of? My house and stuff. What's this brown stuff on the windows? Dirt. What's this rusty, dusty, dirty screen? It's a screen. What are all these big old things out here? What? Trees. That's right. Don't shout them out. What are all these little things? Leaves. And these bushy things? Bushes. Right. So, you've got 2 seconds looking through a dirty window, a crud-covered screen, all these trees with all these leaves. 5 bushes, 2 more bushes, 7 bushes, 7 bushes. So what do you think? Isn't it possible you just saw 2 guys? Okay. He has questioned his way down the road to get the answer that if he'd have just asked it out of the blue, he never would have. But by taking those little tiny incremental steps, he's gotten the witness to go with him. And that's what I mean by questions in a deposition, where you're trying to get someplace using those little bitty steps. And then he says, my favorite thing, which on my last trial, unless I'm in federal court, on my last trial, I'm going to terminate an exam by saying, I'm finished with this guy, but I'm not there yet. And even then in federal court, I wouldn't do it. All right, Rule 4, this is from a brilliant lawyer who tried cases in Texas for decades, Scotty Baldwin, and it's LTTFA. And I'll morph the F from the way he said it, but it's listen to the freaking answer. If we're not listening to the answers that we're getting, if we are not paying attention, and this particularly happens at trial because nerves, because yellow pad, because script, because we have so many things that we want to make sure we cover. If we don't listen to the answer that the witness hands us, we're missing the golden opportunity to follow down the unexpected path that has just opened before us. So LTTFA, we have got to teach ourselves to listen to the answer that the witness gives us. Rule 5, this is my great law partner, John Howie. John was all my partners are aviation lawyers, but he was an aviation lawyer. He was military. He was a pilot. He was very terse in his examinations. And he did this, he did it in depositions, but he did it in trial also. And the point of the answer exactly is, or words to that effect, particularly in front of a jury, whatever the witness hands you would hand to him, he would go, exactly, that's exactly right. And it would rattle witnesses who were actually disagreeing with him, because he would appear to exactly. And regardless of what they say, you're saying exactly, that's right. It keeps the witness off of solid footing. After a trial, he had a juror come up to him and say that he won. Oh, Mr. Howie, I really thought that expert just had you, but you just standing there at the podium going, exactly. And you said exactly. And we thought, well, we just must not have understood what the witness was saying, because you were just going along with him. And so we figured we didn't understand it. And it must be what you said happened after all. So by not showing that you have been dismayed, to say the least, by what the opposing witness is saying, you can get a lot of traction. It doesn't keep you from going back and trying to undermine the testimony. Rule 6, the single most important thing, this is particularly true at trial, and that is this. And this little sticky note was on the yellow pad of a trial lawyer that has probably tried 500 cases. And I was a young lawyer, and I looked over there, and he had put on his yellow pad as he began his cross-examination, lead. He's reminding himself, lead, 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 lead in cross. But if you look out to the side there, he's got his page and line from the deposition. He knows that he's got the answer he wants on page 6, line 13. And the next question he's got on page 12, line 19. So he's going to get what he wants because he can impeach with it, but he's reminding himself to lead. And that is critically important, but it has a corollary. And this is the corollary. And this is my favorite thing to do, particularly in a deposition, but it also applies at trial. And that is, you lead yourself to a place, and you lead your witness to the place where you can suddenly, after all that leading, drop in the open-ended question. Do you remember law school? Oh, who was the professor? He had the thing about the person getting their nose bit off, remember? And it was never ask a question you don't know the answer to. I say there's a corollary to that there are times when you can, and here's an example. We've got a case involving a patient with meningitis. It's important to closely follow the signs and symptoms of meningitis, and we've been talking about meningitis, and we're going on about meningitis, and how important it is to follow it. And these are all the signs and symptoms. And so I've been leading. It's important to closely follow. Yes, it is. Boom. Why? Again, we're going to have a chat about objections someday. What exactly is wrong with the form of that question? Is it too long? Does it assume facts not in evidence? Is it too complex? So obviously that was a ouch, that hurts, because I don't think I want to hear what's coming next objection, because the patient can deteriorate and die extremely fast. All right. So what has happened is this witness has been led to a place where we've talked about the dire consequences of meningitis now for 15 pages. And then boom, the why question. One of my great friends uses the expression from his mouth to God's ear, right? This, because patients can deteriorate and die extremely fast, is the heart of what I'm proving in the case. They didn't follow him close enough. He deteriorated and died because nobody was there following him. And boom, it comes straight out of his mouth. Extremely effective, because then you read that back to the jury in closing. What did the defendant himself tell you about why it's important? Because patients can deteriorate and die extremely fast. Ditto with the how question. Again, opiate naive. So opiate naive patients, we've now had 5 pages of discussion about opiate naivete, which is they're not used to it. They haven't taken them. They're different from chronic users. Chronic users can take a honking big dose and nothing happens. Opiate naive patients, on the other hand, with the same dose, have a different reaction. And we've been talking about that. And yeah, I guess, yes, I guess they would be different from the chronic user. Boom. How? Again, the open-ended question. Do I know what he's going to say? Well, pretty much, even though I'm not leading him into it the way we think of. And again, objection form, same thing, right? Because this is going to hurt. You're not going to like this answer. So you got to say something. But boom, because it may cause them a much stronger reaction than in the chronic user. The heart of my case right there, to read back to the jury or play back to the jury later. This is what we were trying to prove, was they overdosed this poor man and he stopped breathing because he was opiate naive and couldn't take the big dose that he was given. So lead up to that moment when you know that you're going to get the answer you want, and then ask it. This is one of my favorites. Don't fight on their turf. I had a case involving neurosurgery, and their neurosurgeon just ate my lunch on direct. I mean, he was strong. He was credentialed. He wasn't a high mileage witness where I could go after him for always being on the other side. I could have probably done about 10 things with him with sort of de minimis benefit. You're getting paid $1,000 an hour. Well, so is everybody else. And in terms of the content of his testimony, I wasn't gonna. He was not going to succumb to the how and why questions, and he was not going to give me cookies. So what I did with him, and I suggest this to you as potentially invaluable, I asked him exactly 5 questions. We were in Dallas trying the case. My expert had been the treating surgeon. He's also from Dallas. So I'm drawing the distinction that he's from San Antonio. He had never seen my client, David, never seen him. And in between these 2 questions, all right, you're from San Antonio. I paused a real long time after he said yes. Enough that the judge looked up to see, had I dozed off or something. You've never seen David? Again, he says no. Again, very long pause. You've never examined David? No. Very long pause. Now the judge is clicking his pen at me. You've never treated David? In fact, you can't even point him out. And I had moved him from behind me back into the spectators. That was it. That was the only questions we asked in hopes of neutralizing this expert who otherwise was unneutralizable. And the only thing the jury remembered, oh yeah, the guy from San Antonio. They totally discounted him. Now you got to have some chops to do this, because you know, there's lots of other things that are in the cross-examination manual. He's making thousands of dollars. You know, he was wrong about which page something was on. He probably should have disagreed with, you know, there's a lot of other stuff that's on the list. But all the jury remembered was, oh yeah, the guy from San Antonio who couldn't even pick the plaintiff out in the crowd. Whereas the treating surgeon, when he came down there, gave him a hug. So consider that, because really that's what you're wanting. You're wanting them to leave the cross with a label that you can then refer to in cross. You know, the guy from San Antonio, what does he know? He didn't even know what David looked like. So don't repeat the direct. Yeah, we all learned that in law school, but just refresh that on your list, because why would you want to remake the points that have hurt you? And this goes to back to the original, why are we doing this, have a point. If you've got a report, or if you've got a judge who is going to hold them to the report, or if you have a way to fix their testimony, why are you even doing a deposition? What is the point of getting some guy to bill a whole bunch of hours taking a deposition that you don't have to have? You got to pick your approach, and this goes back to the label. Do you have lots of trying to prove that this guy has many inconsistent statements or inconsistencies in his testimony? That's one way to do it, but if you've got one really big one, consider just sticking with that. I think juries are sick to death of how much money are you being paid, because everybody's being paid, and I find that, unless it's really extraordinary, not to be useful. You know, and sometimes y'all remember the Paul Newman movie where the defense expert was the PFD, the Prince of Effing Darkness. You know, every once in a while you're going to try and prove that, but most of the time, these are just people doing their job, and you're not going to get that proof. But you got to pick, what is my approach to him that the jury's going to remember, so that they leave with the label. We just took a deposition of a highly qualified expert who has been practicing medicine for 55 years. And his tag is going to be the old guy when we go to trial, because he came across as old and not cutting edge. And so he's going to be the old guy. We had the guy from San Antonio, and then we had somebody in a different case who had only done the procedure himself 1 or 2 times. So he's the inexperienced one. So that they take, the jury in particular takes a label away that you can then use to your advantage throughout the rest of the trial. Okay, laying a predicate. This is fun. I find dumbed down witnesses to be the most fun to cross-examine. And these are the witnesses who have been told, and I find it particularly with nurses. And if any of you guys are nurses, you'll know what I mean when I say that sometimes lawyers are living in a different century, and nurses are little ladies in little white caps who do what doctors tell them, which is not really the reality anymore with an independent profession. And if the nurse comes into a med mal case and she's been dumbed down, don't know nothing, here's where you lay your predicate. And the predicate is, you know, ma'am, you are giving a drug called lidocaine, yes, and you're required by the Board of Nurse Practitioners, whatever it's called in your state, you're required to know the effect of the medications you give, yes, and you're required to know their indications, yes, and you're required to know their contraindications, yes, and you're required to know medicines that they can interact with, yes, and the correct dosage. So you go through about 25 questions, because you know where you're going. You go through about 25 questions that lay a predicate that do not leave them a place to be dumb anymore. You've got your patter there, and they can't say, well, I don't know what lidocaine's for, I just gave it because the doctor ordered it. No, that's not how it works. So you've got, for whatever the discipline is that you're cross-examining, you know where you're going. So what's the predicate that you need to lay to get them to, in this case, the act requires that they know the implications and contraindications of the med that they give. So you've got the prep, you've got your patter, so that you could just build that base and there's no place that they can go to escape. Box them in. This is, sorry, a little bit long, but here's this just happened, and here's the story. We had a case, we're working on a case where I want something to be to have taken 10 minutes, okay? And one of the witnesses said it took 10 minutes. Their team does not want it to be 10 minutes. They want it to be something like, 0.4 seconds or a minute or something. So this lady comes in and she does not want to say it took 10 minutes. I can't give you the exact time. I am never going to get her to say it was 10 minutes because she is there to say it was not 10 minutes. So here's box her in. Here's where we go. How long did it take? I can't tell you. I can't give you an exact time. You're just going to say less than 10 minutes. That's as far as you're willing to go. Again, I can't give you any specifics. So I am building a box from which she cannot escape. I just don't want to hear something different at the courthouse so that all you're going to say is less than 10 minutes. You're not going to pin it down any more than that. Nothing more specific. She says, I know what 10 minutes feels like. It wasn't 10 minutes. Okay, I got that. It was less than 10 minutes, but you're not going to pin it down any more than that. No, this is my one chance. They're not going to let me come back. Less than 10 minutes. Okay, you are not going to swear to any specific amount of time or not. No, I'm fine with that. She's this vague concept of something less than 10 minutes. 9.5, I'll live with 9.5. So building that box from which they can no longer escape, instead of having this roaring fight with her about, well, doctors know better, and the doctor said 10 minutes, and et cetera, and you don't have anything written down, and you don't have any proof, building that box from which they can never escape again. Especially adding in the semi-argumentative, this is my only chance, I can't come back, want to know what you're going to say at the courthouse, and want to know what you're going to tell the jury. So building a box is, I think, a tremendously effective technique. Okay, I want to spend a couple of minutes talking about the professional witness. And by professional witness is not really a compliment, as I suspect most of you all know. Now, I can't do that because there are some, for example, medical examiners who have done it a billion times, but they're not making their living being witnesses. They're making their living being medical examiners. This is really about people who are making their living being witnesses. And in these cases, one, if you're going to do the deposition, having made your decision, why am I doing this? Because I need to. Why? Because then the purpose of the deposition in part is to lock them down. To do that, it is impossible effectively to cross-examine a professional technical witness unless you know the subject matter of your particular case as well as they do. Back to that neurosurgeon, the guy from San Antonio. Back to the guy from San Antonio, I'm not going to know neurosurgery better than he does. I'm usually, by the time of trial, we're going to know the issue in the case, as well as the professional witness. But still, when somebody is a highly skilled person in their field, we're probably not going to know the subject matter better, but we are going to know our little fact situation. I'm going to know on the 10-minute lady there, everything in the records that supports 10 minutes. Well, she doesn't know that, and she won't by trial. I'm going to know everything that every other witness has said about it being 10 minutes. She won't. So the subject matter of the particular case is something that no matter how experienced the witness is, we who are living the case are going to know better. And so you've got the subject matter, and then you do your due diligence on the witness. These pros leave a long trail, and there is a lot there to be found about them. But as you're pinning them down, and my partner, Mike Davis, who we lost this year, but Mike was a master at this because he had the patience. He would put his yellow pad down and he'd say, I want to get every opinion you're going to give. And this is hard for me because I want to run down the rabbit trails because of LTTFA, listen to the freaking answer. I'm listening to the answers and I'm rocketing off here and there, getting concessions. You got to remember to go back to that list you're making. You got to LTTFA, you've got to get your concessions, but get back to that list. And then what he would do, he would get a complete list. Then he would get a complete list of everything that supported the opinion. And this is tedious and it's difficult and it's not fun like we have at trial with cross, but it's critical in order to, so that you don't get something brand new at the courthouse. And at the end of making this list, he'd put a sticker on it and say, he'd hand it to him. Is this accurate? Did I write it down right? Is this a complete list? Do you want to add anything? So that at trial, there's not some big surprise, oh, I forgot to mention, not only did I change my mind about which syringe I used, but it wasn't even lidocaine, right? So you've got it pinned down in the opinions. And the commit to any favorable facts is critical. The 10-minute lady, later in the deposition with her, we went through all of the things that we know lengthen the time out towards 10 minutes and got her to admit all of those. She didn't think she was deviating from her, I know it's 10 minutes testimony, but she admitted to all of the things that build to 10 minutes. So you commit the witness to those favorable facts. Okay, sources of goodies on these professional witnesses. Everything is on the web. We had yesterday a vanishing pharmacist. We get a call from the defense lawyer. We can't find her. We're going to have to scrub the deposition and reset it. They really don't want us to take it. Well, it took about 25 minutes and we found her, just, Googling around, looking at all of the different find people apps that exist on the web. So it's out there. We also this week found a physician who was practicing in Texas who was not licensed in Texas at the time, because all the licensing bodies have a list of everybody who's licensed in the state. And then the databases. I don't know the specifics of what you guys have in Colorado. I know that AAJ has national databases, as do the defendants nationally. And then within Texas, we've got the plaintiff databases, and there are equal. I defended a few cases and somehow got into the defense database and I can't get back out of it. And I keep getting, hey, we want, what you got. And I was like, I'm not giving it to you. I'm not on your team. But those databases have a ton of info. The thing that is most interesting, and we used to great advantage in getting a crazy person struck, was prior orders striking the witness. And some of that we were able to find pre-deposition where they were struck under Daubert type standards as not having the expertise that they claimed. But then we found more during the deposition when we got him to admit it. And that's persuasive to the trial judge, who's like, well, I'm not going to be the only one letting this crazy person testify about this if, 8 other judges have struck him. So that is good fodder. Impeachment, everybody knows that. You're going to commit him to the prior testimony. This is now on the stand, but can also occur in deposition, because there are times when it is more effective for your client to get an expert withdrawn. And if you can demonstrate to the attorneys or to the other party that their witness has already said the opposite in 6 other cases, they may no longer be an expert. Now, they may just go get a better one. You have to decide if you want to clobber him or not. Remember the thing they taught us in law school about everybody hates cockroaches, but if you pull the legs off of them, they're going to sympathize with the cockroach. You got to decide, are you going to try to nullify him in the deposition, or is that just going to mean they go get the guy who really is qualified? But if you have it, and you can pin them down to where they're committed, no place to go next, like the 10-minute lady who is now in that 10-minute box forever, you've got them pinned. Again, prior inconsistent statements. When was it made? Where was it made? To whom was it made? It was closer to the time of the event. It was at a time when he knew it would be relied on. you're building up all the inconsistent statements to where he can't escape from them, and they are more reliable than what he is saying now. So again, the questions are your friend on inconsistent. Once you prove it up, at the time, did you, ma'am, testify that it was less than 10 minutes and that you could not be more specific? Yes, I did. Stop that whole, oh, it's a movie. Were you lying then or are you lying now? No. You've proved it. The jury's sitting there listening to it. What? On the week after it happened, you said X and now you're saying Y? That's it? So you stop and save your argument for argument instead of arguing with the witness. Yeah, stop. Do not invite the explanation. Do not allow the explanation. And then we've already covered develop strategy. So that is the fun of cross-examining witnesses. I love doing it. I hope you guys do too. I was asked to leave 10 or 12 minutes for questions if anybody has any. So if you do, I'm not sure how that works, but Bruce or Kyle can pick them up. And if not, I have appreciated being here. So somebody let me know.
I do not see any questions. Kyle, do you see any?
Paul, I had a
I
question.
do not. So you people
I
are
had a
welcome to
question.
unmute themselves at this point and ask any questions you have.
Hi, Doug.
Hi, Paul. I had a question. You kind of touched on it with your first of all, thank you so much. I learned a lot in the last 50 minutes. A lot of really good information.
Thank you.
You kind of touched on it earlier with your follow-up if the witness is clearly coached by their lawyer to change their testimony. But what happens if inevitably you get a good admission? I had this about a month ago. I got some really great facts, and then inevitably the opposing counsel calls for a break. 10 minutes later, the witness comes out, completely changes his testimony on this key point. Obviously was coached, what to say and what not to. And, I started, it was pretty obvious what had just happened, but then you ask questions and, oh, you just met with your attorney. And obviously you can't flat out ask them what they discussed, even if it's really obvious. And he's just saying, oh, I just remembered. And upon further reflection, that sort of thing. Do you have any tips when you have something like that and the witness is clearly dodging and denying that that he's been coached up to give a certain answer, how to rebut that in a deposition?
Yeah, there's a couple of things you can do. So one of the things that I do before we take breaks is especially if I think something like this is coming and I've gotten some good cookies, right? Is I'll say, now you've understood my questions so far, haven't you? And you've answered truthfully and to the best of your ability. And depending on how big a fight we've had, sometimes I'll say, and have I been courteous to you? Sometimes I don't ask that. But if the other side wants a break, or if I think there's going to be some coaching in the hall, I'll pin them down with those. You've understood everything I've asked you so far and you've answered truthfully. And then they come back in. Well, now, right before we left, I asked you that you understood me, and you had understood me until you had a break and talked to your lawyer. Is that right? Because talk to your lawyer is not privilege. Content is privilege. And so at 10:47, you had understood my questions and answered truthfully. And at 10:52, you came in with a different answer. Is that true? So you just, again, you're kind of going around the periphery, putting all of the edges on it that and you're going to get to show the jury if you videotaped it, or you can read it to them that, at 10:47, he was right there with you that, it was the wrong syringe. And then at 10:54, no, that's not what happened. So those are a couple of things.
Okay. That's great. That's very helpful. Thanks.
All righty. And you can also get the court reporter and I've had trouble with this lately with court reporters, but you can get them to read back the old answer and then you have it in front of you and you can, depending on how much time you want to spend arm wrestling with the guy. So, this is exactly what you said at 10:52 and, just depends how how important it is and how far you want to go with it.
Okay, thanks.
You're welcome. All right, all set then, Bruce?
Yeah, if there's no other questions, thank you again, Paula, for the presentation. It's very informative.
Well, I appreciate being with y'all, and go have some fun. I mean, if you can't have fun cross-examining witnesses, then, you know, might be time to do something different, because this is about as much fun as you can have in law practice. Thank y'all.
And just to reiterate, I will get the CLE form, the PowerPoint presentation out this afternoon, and then the video recording will be live by the end of the week. So if there's anything you want to revisit or catch up on in case you came in a minute or two late, that will be available on our BCBA YouTube channel along with all of our other Zoom recordings. So thank you again to Paula for presenting today, and thank you to Bruce for setting this up.
All right.
Have a great day, everyone.